The next speaker is Professor Anne Peters, who is the director of the Max Planck Institute of Comparative Public Law and International Law. And I would also like to say that Anne Peters is a member of the Venice Commission in respect of Germany. So she's going to be speaking of the Venice Commission and the incidence of the Venice Commission decisions and recommendations towards domestic law.
Merci beaucoup, Laurence. Et merci à Julia Motok et au programme de master pour l'invitation. C'est un très grand plaisir pour moi d'être ici et on voudrait vraiment vous inviter de devenir membre actif de la Société européenne de droit international. Je voudrais maintenant parler sur la commission de Venise avec laquelle votre pays a eu aussi des points de contact. Et j'ai fait un handout, mais seulement 20 copies parce que les organisateurs ont dit qu'ils veulent épargner du papier. Donc, quelques-uns pourront peut-être regarder dans mon handout. I would just like to tell you that the title of my 10 minutes is The Venice Commission as a Facilitator of the Implementation of International Law and Domestic Law. And the word facilitator is already the thesis of my 10 minutes. That's as good as it can get. The Venice Commission, which I think issued already 9 opinions on Romania, most recently in December 2012, a very important opinion on all kinds of constitutional questions of Romania, including the referendum on the president and the use of emergency executive orders. This commission has been founded in 1990, and it is, according to its statute, an independent consultative body. It was promoted by an Italian, La Pergola, who was before also Advocate General and later judge of the European Court of Justice in Luxembourg. The background of the foundation of the Commission was the fall of the Berlin Wall and the path of Eastern and Central European states to liberal democracy, including their path to become members in the Council of Europe. The legal basis is now a resolution of the Council of Europe. And the members are 59 states, all 47 members of the Council of Europe, and 12 states from other world regions. Most recently, the United States became a member in March 2013, which caused some debate in the Commission and critique by Russia, and the Swiss member of the Venice Commission resigned because of that event. Because some states of the US, as you know, still have the death penalty, and Gret Haller, the Swiss member, took this as a pretext, I think, to resign. The mandate of the Commission... yeah, exactly, yes, I think so. The self-description of the Commission on the website is that it is an independent think tank and it grants constitutional first aid. The objections are basically threefold. First, legal harmonization. Second, promoting the rule of law and democracy. And third, examining the problems raised by the Working Group of Democratic Institutions and their reinforcement and development. That's on the website, or it's in the statute, I think maybe in the statute. So how does this function? The states send independent experts who act in individual capacity, and there is a secretariat of lawyers, which is very competent, I think, and there are sessions 4 times a year in Venice. The next session is next week. And the instruments or forms of action which the Commission uses are, first of all, in its capacity as a think tank to produce studies. For example, there was a recent study on lobbying in parliaments. Or there is an important, I think, report on the rule of law, which is very good. Then the Commission produces draft guidelines, for example, guidelines on the freedom of assembly. This is now under review because one background is that there are lots of problems in Russia with freedom of assembly, so the guidelines are in the process of being updated. And also codes of good conduct, for example, in electoral matters. The second area is, under the keyword constitutional first aid, the issuance of opinions on individual problems. And these opinions can be requested either by organs of the Council of Europe or by the member state itself. That's most common. And the member states are sometimes doing that under pressure, under certain pressure of the EU or the Council of Europe. For example, the president of Romania requested an opinion in 2012 on issues related to the constitutional crisis, as you know. Now, what are the standards applied by the Venice Commission? First of all, if internal law is scrutinized, for example, electoral laws or laws on the judiciary, then the standards are, of course, the constitutional law of the state itself. But when the constitution itself is under scrutiny, then the standards are what I would call higher law, hard international law, notably the European Convention on Human Rights, but also international law in general. But notably, the Commission also applies soft international law. For example, documents of the Parliamentary Assembly of the Council of Europe. And the Venice Commission also develops in a self-referential fashion its own yardstick by quoting its previous opinions, so it tries to behave like a court in that respect. And it also applies what I would call transnational law. It uses the word the principles of European constitutional heritage, which it identifies through constitutional comparison, including constitutional practice, not only law on the books. For example, the opinion of December 2012 on Romania mentioned the principles of European constitutional heritage in its opinion. The question is, what is the standard? Is it admissible? Is it legitimate to use this as a standard? I think yes, it is based on the Venice Commission's mandate of legal harmonization and of promoting the rule of law and democracy, because this mandate is very dynamic. It includes legal development. Therefore, the Commission is empowered to develop, I think, best practices as a maximum standard, as opposed to hard international law as it stands as a minimum standard. So there is what Judge Motok just mentioned, an interaction between international and domestic law, both in a horizontal way and in a vertical way. The Venice Commission contributes to a horizontal approximation of laws, notably constitutional law, but this horizontal approximation occurs through, and this is very important, I think, through a common or parallel orientation of all members' domestic legal orders at the international legal standards concerning the rule of law, human rights, minority protection, and democracy. One could say, to stay within the image, that this is a vertical orientation up to international law, and this is an orientation at a body of international law which we might call international constitutional law. And this body of international constitutional law informs domestic law reform. Now, is the work of the Venice Commission legitimate and is it effective? Concerning the legitimacy, I think that the standards need not be so high. For example, the members, the experts, they are not elected by parliament, but just appointed by the executive. But because the opinions are anyway not binding, this lack of democratic involvement is, I think, not such a problem. The experts have legitimacy through their expertise. Now, the other question is, what about the effectiveness of the Commission's work? Of course, here we have to distinguish between effectiveness for the state which requested an opinion, or effectiveness more general also for other states, and also for international organizations. And as you know, the opinions are not binding at all. They are only advisory, so they don't have any direct effect. They can at best deploy an indirect effect to be taken into account for in law reform and in interpretation of domestic law. And when we speak about effectiveness, we also have to distinguish between mere quantity, so citations to the Commission, but on the other hand, we should look at the quality. How good are amendments of domestic law undertaken with a view to Venice Commission's recommendations? And the third aspect is, of course, whether these amendments are then really applied. Unfortunately, there is no follow-up mechanism to really systematically scrutinize the follow-up of the opinions. Recent opinions show a very mixed balance, and I think the most prominent example besides Romania is Hungary. The recent opinions issued on various aspects of Hungarian constitutional law, and they have been followed, but many have not been followed. So in the end, the question arises whether the relatively modest success of the Commission resides only in the soft power of persuasion, or does it stem more from hard economic advantages, such as brought about by EU membership? For example, Croatia was a willing client of the Venice Commission when it pursued the objective of becoming an EU member. But here we have the paradox of carrots and sticks. The carrot is the EU membership, but this carrot can only be extended as long as the state is not yet a member. For example, now, Serbia. Once the carrot has been eaten, once the state has become a EU member, then only the sticks can be applied to the EU member state in the form of sanctions. For example, with regard to Hungary, the infringement proceeding of Article 258 of the Treaty on the Functioning of the EU has been instituted, but only with regard to very few problems of the overall constitutional mess in Hungary. So in the end, I think the process of persuading states and the process of adaptation of states to the standards of the European constitutional heritage depends very much on meta-legal or non-legal preconditions. For example, on the democratic infrastructure which exists in a state. This brings me to my conclusion. The conclusion is legal culture matters. The development of a legal culture of compliance with domestic constitutional law and with international law is crucial. And please allow me to conclude from the opinion of the Venice Commission on Romania of December last year. I quote the Commission: "Compliance with the rule of law cannot be restricted to the implementation of the explicit and formal provisions of the law and of the Constitution. It also implies constitutional behavior and practices which facilitate the compliance with the formal rules by all the constitutional bodies and the mutual respect between them." So because the legal culture is in any way a soft good which must grow by itself, it can in any case not be imposed top-down. It is therefore altogether fitting that the Venice Commission is a soft body in which international and domestic standards, which are confluent standards, are applied, developed, and are suggested to states, not imposed on states. And their full integration into domestic law and their real respect in practice is left to the state. Of course, to the state organs, and these organs are people, are human beings, and they must respect the law as a matter of cognitive insight and as a matter of goodwill. It may well be that the shadow of hard sanctions helps, but in the end, the Council of Europe is a reputational community. Member states' sovereignty, to come back to the core concept of international law, manifests itself in good standing in that community. Thank you.